Well, good morning. I hope everyone can hear me okay this morning. It's Lisa K. Crawford here with you. I hope everybody is off to the start of a wonderful Saturday, October 22nd, 2022. And we're here this morning to talk about living wills, why everyone should have a living will. One of the things I think is important, though, is we have to distinguish between a living will and a regular will because they're not the same things. So I want to make sure that we have a chance to talk about both of those things. So, what I'm going to do is I'm going to share my screen as we begin our discussion. Um, I have some documents here that I want to share with you. So, be patient with me as I navigate through the system. Let's see, Lise. Did we get this right? Hold on, guys. No, we did not get this right. Well, that's okay because we can continue to talk about some of the things here that we need to talk about this morning. And so to start, we'll just go ahead and define a will. Person, place, or thing. It's a thing. It's a legal document. And it expresses the wishes of the person making the will. That person is called the testator. Um, Obviously, when the will takes effect, that means that the testator is deceased. And the deceased person is referred to as the decedent. All right. Um, and another thing you should know is that a will only takes effect, pardon me on my screen here, a will only takes effect at the time someone dies. Okay. So that's the basics for a will. A will can address the the distribution of the assets of the deceased person, and the people that receive those assets are referred to as the beneficiaries of the will. Okay, so that's one thing you need to understand also about a basic will. You also have heard that a will is referred to as a last will and testament, and that's absolutely true as well. So you have a will, um, and you've also heard it referred to as a last will and testament. So either way, it's a will, but it is different from a living will. One of the other great things about a will is that you can appoint guardians for minor children in a will, and I think this is a really big thing. So a will is a valuable document. Of course, as an attorney that practices in estate planning and probate administration, I think everyone should have a will and a living will. By the time you're 18 and you're getting out there in the world, in the streets, driving cars, going to work, going to college, doing things, um, that's the time when you need to have certain documents like these in place. All right. So that's the basics on a will. And now we'll just move to talking about a living will. I feel like something happened to my sound, so I hope everything's okay here. I'm gonna speak with you with regard to the Florida statutes and the Florida statutes that deal with healthcare advanced directives is Chapter 765 of the Florida statutes. these things, everything's on these days, everything is on Google. That makes it a lot easier. But you can see that the statute has suggested form of language for a living will. It doesn't have to be exactly like this, but you're basically saying he calling a document a living will. Um, and it is a document, another legal document. So before we get into some of the statutory language, let me just go ahead and define it so that we have a clear difference between a will and a living will. So it's another legal document that you don't have to die for it to be effective, but you are incapacitated when this document becomes effective. So it's a legal document that informs your doctors and your family in writing of your medical preferences in case of an emergency that leads to end of life care. Um, in other words, you could be in a situation where you're uh, having facing a terminal illness. You could be in a persistent vegetative state. Um, you could be in a situation where there's just absolutely no chance for recovery and you are facing death, closer in time than not. So it's a situation like that. That's when a living will becomes legally effective. But before anyone gets to a situation like that, you take care of the document now. You get it done. You fill it out. It tells your doctors and your family what your wishes are in writing, and you appoint the persons to carry out your wishes, because if you are unconscious or if you cannot make healthcare decisions for yourself, um, excuse me, if you're in a situation like that, then I feel like there's some weird echo, guys. Sorry. Hold on one second. If you're in a situation like that, then you definitely want to appoint someone who you trust who will be able to carry out your wishes, what you want. That would be the goal. All right. So that's how I would distinguish between a will and a living will. The will takes effect upon death. The living will takes effect upon incapacitation, in a circumstance that leads to end of life care. So you're facing death. You may not be dead. You may be unconscious. You may be in a vegetative state. You may have a terminal illness and not be able to make decisions for yourself. That's when that document, the living will, takes effect. And it can also address other things like other medical treatments that you may want to put in your living will, such as circumstances pertaining to fibrillation or dialysis. There may be certain medical uh, conditions you want met or certain things you want done. If you're not around to say it yourself, your living will can address those things. Sometimes people will add language with regard, they're called DNR orders or do not resuscitate orders. Um, Say you're up in age, and if you are naturally dying, and say if your heart is failing, some people don't want medical treatment to try to resuscitate them and bring them back. They just want to leave naturally and let it be. So a living will can address a number of things like that as well. So when should you get this document? I say the moment you start walking out the house and you have keys to the house and you're coming and going and you're doing things and you're living your life, this is the time to have documents like this. So, just going back now and looking at the statute here, chapter 765, it gives you some idea of the language you can use. For instance, a declaration made this blank day of this year saying, I, insert your name, willfully and voluntarily make known my desire that my dying not be artificially prolonged under the circumstances set forth below. And I do hereby declare that if at any time I am incapacitated and then these are the conditions you would have to check off. I have a terminal condition, one. I have an end stage condition, two. I am in a persistent vegetative state, three. So you could check off each one of those conditions under which your representative could act on your behalf. A lot of people check all three, that if they're facing those type of circumstances, and if my primary physician and another consulting physician have determined that there is no reasonable medical probability of my recovery from such condition, I direct that life prolonging procedures be withheld or withdrawn when the application of such procedures would serve only to prolong artificially the process of dying, and that I be permitted to die naturally with only the administration of medication or the performance of any medical procedure deemed necessary to provide me with comfort care to alleviate pain. It is my intention that this declaration be honored by my family and physician as the final expression of my legal right to refuse medical or surgical treatment and to accept the consequences for such refusal. In the event that I have been determined to be unable to provide express and informed consent regarding the withholding, withdrawal, or continuation of life prolonging procedures, I wish to designate as my surrogate to carry out the provision of this declaration. So, in this document, you're not only saying, letting everybody know what you want done under certain circumstances with regard to your medical situation, but you're also appointing your representative in this document to also be able to legally carry out your wishes. So then you would name that surrogate, and that person's name would be in the document. Many times, I encourage people to put an alternate in the document. Like if this person is not available and cannot perform, then you would say, the second person's name who could be an alternate. Um, and a surrogate is a designated representative to carry out an official function of some sort or to carry out a duty on someone else's behalf. So you look at it this way, that the person making the living will is the principal. That's the principal maker of the document. And they're in effect appointing an agent or representative to carry out their wishes with regard to their medical care. And let's see what else I want to say about that. I think you guys might remember. Let's see if I can get this right here. You guys remember the case of Terry Schiavo. And this was one of those Florida cases that really kind of really made people aware about the importance of living wills. And I'm going to read just a little bit of this. Let's see. So this was from, wait a minute, this article was from 2015. So Terry Schiavo, wow, I think she died in I think two. Well, she suffered a cardiac arrest in 1990. So let me just read a little bit of this. She was 41. She had spent nearly half her life in a vegetative state after suffering a cardiac arrest in 1990, causing a severe lack of oxygen and brain damage. She had a highly publicized case surrounding her husband's plea not to keep her artificially alive. And that caused a great buzz and debate around the world and at the U.S. Supreme Court. Um, let's see, we're going to go on and talk about a little bit more. This article mentions today some families still battle at the bedside. The condition of, they talk about Bobby Christina Brown, how she was found face down in a bathtub January 31st. That, she was a young person, but I don't believe she had a living will in effect. So they go on here to talk about what happened in the Terry Schiavo case. At the heart of the case, Michael Schiavo, her husband, began requesting in 1999 that she legally be allowed to die. He believed she would never emerge from her comatose state. And I believe at this point it had been like 5 years that she had been in the state. He believed that she would never emerge from it, as every doctor who examined her had said, I believe. He did not want her to live in a permanent vegetative state, unconscious, unresponsive, and unable to interact with the world, since he felt that she would not want to be in that condition. Terry's family bitterly disagreed. They still believe that to this day she would have wanted to live, that her husband did not have her interests at heart, and that they were unfairly pushed aside in their effort to save her life. Um, this case, that what began as a private dispute, moved from Florida circuit courts to district courts to state courts to federal courts to Congress, and then to the United States Supreme Court. President George Bush almost created a constitutional crisis between the courts and the executive branch in trying to override the Florida courts, which had time after time backed Michael Schiavo's decision. Former Senator and Surgeon Bill Frist saw his presidential dream disappear when he challenged Terry Schiavo's diagnosis without examining her. Wow. So a lot of politics at play. The Vatican wound up challenging U.S. law, as the Schiavo case affirmed allows the stopping of artificial food and water under certain circumstances. The Vatican said food and water could not be stopped, thereby leaving many Catholic healthcare institutions and Catholics in this country and others uncertain as to how to manage requests to let a patient die by removing a feeding tube. Wow. Just, you can see just a whole lot. The facts did not support those, including Terry Schiavo's parents, who held that she was not in a permanent coma. An autopsy definitely settled that question. Her brain was severely atrophied, weighing less than half of what it should have. No treatment then or now could have reversed the brain damage she suffered. She was not conscious for all those years and never would be. So, what has changed in America? It's been more than 10 years later. It's been more like 17 years later. Still, though, too few of us fill out living wills, advance directives, which is also what a living will is referred to, or we fail to select a surrogate decision maker in writing. In many states, only married relatives have the standing to make treatment decisions, leaving those who are living together but not married at risk of being ignored. Oh, let me take this. If I can turn this off over here, I will. Okay. I think I can. Yeah, great. So, and I wanted to make sure that this screen is, I should also be making sure that you can see this. Sorry about that. All right. So in Florida, we don't have to worry about that. I know in my home state of Ohio, you don't have to worry about that. You can appoint a family member, someone close to you, someone you trust, uh, to be your surrogate regarding your living will. It doesn't legally just have to be a spouse. Um, this article goes on to say some other things about some other laws, but just to finish up, some states have laws voiding written patient directives about what should be done if a woman in Schiavo's condition is pregnant. Other states will only honor written directions by the patient, not prior conversations or oral conversations. And 3 states have enacted laws since Schiavo's death that allow the terminally ill to end their lives, laws for which Terry would not have qualified since she herself was not competent or able to communicate in any way. And that's a beautiful picture there of Bobby Christina, who was the daughter of the late singer Whitney Houston. Um, she was at an event there in 2012. The article goes on to talk about, in addition to Bobby Christina Brown's plight, um, you know, there's another young person here I think they're mentioning who also is still being maintained by artificial means in New Jersey, Jahi McMath. I'm not familiar with that person. All right. So the final paragraph of this article, which I think is really important here. So basically, in America, both young and old, we still need to try harder. Um, not to avoid talking about death and one's wishes, about what one would want if disability or illness makes communication impossible, so that there will be fewer Terry Shivos in the future. And I think that's one of the most important things is that young or old, we have to be aware that these things exist. These issues exist in life and they are going to come up and we have to be ready for them, right? And the only way to really get ready for things that happen in life, it's kind of like life is going to happen whether you're prepared or not. So the only thing you really can do is engage in some advanced directives that says kind of like, well, if this happens, then this. And if this happens, then this is my written directive on that. And if this circumstance happens, then this is my written directive on that. So, whatever those likely contingencies are, things that could happen, you hear that terminology that happens out there, right? It's true. We do our best to protect ourselves. We try to drive safely. And then you hear stories about planes crashing into people's backyards and swimming pools. Um, we try to be as safe as we can. And then we go to the grocery store and we want to buy healthy food. And then we walk down an aisle and, we get injured from a slip and fall because of a wet spot on the floor. So things can happen. They can land you in a hospital, that could cause severe injury, that could make you lose consciousness. Things could happen that could I mean, some people go to amusement parks, just to go and have fun, and they leave the place on stretchers, going to emergency for various reasons. So I think you guys get the point. A will is a legal document that's very important, and a living will, I think, is just as important. And I'm going to give you 4 really quick reasons before I end the broadcast about why everyone should have a living will. So, number 1, you the maker of that document. You're the captain of your own ship. You've been managing and running this ship since you could take care of yourself. And your end of life circumstances should be no different in terms of you making sure your affairs are carried out and managed unto till the end. Okay? So that's number one. Number two, when you prepare a living will, you are providing guidance. You're providing guidance to your physicians, you're providing guidance to your family members about what you want. You're basically saying, if I can't make the decision myself, this is how things need to go, right? And it's a legal document, and you should have confidence that your wishes will be carried out. All right. So, number three is the document provides clarity. It provides clarity. And why is clarity important? Because you don't want anyone to get it twisted about what your wishes are, what you want done to your body, how you want your body to be treated, if you want um, food and hydration, if you don't want food and hydration, the circumstances of that, you can put that in writing and it can be spelled out clearly so that no one's confused. And number four, I would say it kind of goes along with number three. But number four is you are reducing the stress, the emotional stress, and the burdens of your family members when you have a living will, because they are looking at that document saying, well, this is what she wanted, this is what he wanted, and we are going to oblige ourselves to carry this out and do it just like this, right? And so you cut down on the family stress, because they're otherwise, without a document like that in place, I mean, some of you guys have seen how it goes. There's fighting, there's confusion, there are family members swearing that they'll never speak to each other again. There are folks trying to get medical records, and because of HIPAA laws, they can't get the records of the medical of their loved one. It just gets unbearable. So that's why advanced planning is very important. Um, Estate planning lawyers are really cool people. We're not boring people. We don't just think about death and dying. What we like to do is we like to sit down with people and talk to them about what they're concerned about. That's what's important, is to have the conversation. Because once you have the conversation and you understand what clients are concerned about, of course, you can draft the legal pleadings that go along and match their concerns and address their needs, right? So everybody doesn't need the exact same document, but when it comes to a living will, you do. Oh, yeah. I would say everybody needs to have a living will. So a lot of times, even if you can't afford an attorney as far as drafting is concerned, um, you can, some people go online and try to find these documents. Of course, I wouldn't advise it. Why would I? I'm a lawyer. But some people go online and find these documents, and some people, they get these documents from their medical providers, you know, maybe before they have a surgery where they might have to go under anesthesia, and there could be a chance or risk that they may not come back from that. You want to have a living will in circumstances like that too. So the earlier the better. All right, guys, I'm Lisa K. Crawford, attorney at law. My office is in East Fort Lauderdale, Florida. I'm licensed in Ohio and Florida. If you need any help, feel free to give me a call. My office number is 954-870-7600. And I'll be back again and sharing more information. This YouTube show is called Legacy Talk. I hope you will like it and subscribe to it and continue to follow me. All right, have a great one. Talk to you later.